The Supreme Court ended its term on June 27th, and we saw a number of key decisions. Our readers had some questions. Here are a few of them. Paul asks, I am not clear on what the ruling on injunctions means. Does this not allow a president to create laws, limit rights, and impose measures unilaterally, giving the president dictatorial powers? So certainly, the court is giving the president wider discretion to act and making it more difficult for judges to limit the president's actions. That said, the president is still going to be bound by the Constitution. Plaintiffs, including public interest groups and attorneys general, can still take the president to court. What a lot of us are used to in recent years is the president takes action, issues an executive order, plaintiffs rush to court, and they almost immediately, in a friendly jurisdiction, are able to obtain a nationwide injunction, something blocking his actions often before they even go into effect. What we're likely to see now is different and messier. You're likely to see plaintiffs having to rush to court, possibly in multiple jurisdictions. You may see a patchwork of orders in different states. And ultimately, over the course of days or weeks, you're likely to see the Supreme Court step in. Valerie asks, do you expect that the district court judges will continue to issue nationwide injunctions despite the Supreme Court's ruling? So the Supreme Court has made it much more difficult, but they left open the possibility that district judges could still do this, and birthright is a great example. They've left open the possibility that attorneys general could go to court and say, having this ruling go into effect in a neighboring state still creates chaos in my own state. So what, for example, if you have a parent who's a resident of my state, their child is born in another state, it's unclear, right, whether their child is a citizen, whether they're entitled to certain benefits. And so it leaves open the door that they can make that kind of an argument, that nationwide chaos impacts their own borders, and so therefore they have the authority to have this blocked nationwide. How can the court be considered apolitical and as unbiased interpreters of the law when the conservative and liberal judges so often vote along ideological lines? The liberals and conservatives actually very often don't vote against ideological lines. They vote together on a wide range of cases that just don't tend to be the ones that we cover in the Wall Street Journal and that you pay attention to. There's a lot of workaday cases on which they are pretty united. But yes, it is true that in the big cases that we saw this term, the one involving birthright citizenship, one involving transgender care for minors, whether parents should be able to decide whether their children are exposed to LGBTQ books in schools, that in some of those most ideological and frankly most important cases, the court split along 6-3 lines with a conservative majority really controlling what the court is doing and deciding. I think the answer to this question is to some degree that I am not sure that most people at this point necessarily see the court as apolitical. If you think back just a few years ago to the Dobbs decision overturning Roe v. Wade, I think for a lot of people that was sort of a landmark moment, right, in which they saw the court very quickly after they got a solid conservative majority overturning a long-standing precedent. Christopher asks, it seems this court has made a sea change pushing issues from the courts to the legislatures of either Congress or the states. Or am I mistaken? I don't think that you're mistaken. I do think that the conservative majority on the court sees a more limited role for judges and believes that state legislatures, to a certain degree Congress, although Congress doesn't legislate a whole lot at this point, and certainly the president should have a fair bit of deference in shaping policy. I think a good example of that is a key decision this term on transgender minors, in which the justices said, in essence, we think that states are best positioned to be policymakers on this very difficult issue, this issue that involves a lot of difficult factual questions about whether this medicine is safe and effective, and we think that that is for politicians to be doing and not for judges. You also, of course, saw this in the injunctions case, in which the justices expressed discomfort with the degree to which, as soon as the president takes action, it was almost immediately blocked by the courts. And you see the justices saying, we think the president should be given some range in which to act. And yes, the courts have a role in scrutinizing that, but it should be a lesser one.